We'll be starting in about 5 minutes approximately. Thank you.
Good afternoon and welcome to the Rule of Law program. On behalf of the 9th Judicial District and Eastern New Mexico University, we'd like to welcome the New Mexico Supreme Court, but most importantly, all of you to hear what oral argument is actually like. And it's my pleasure at this point in time to introduce you to Dr. James Johnston. He's the 12th president of ENMU and the 3rd chancellor of the ENMU system. He went into his 3rd year as the top dog of Greyhound Nation just recently. You've been able to see him not only around ENMU, but whether it's helping in other areas of our region, such as Cannon Air Force Base, or promoting rural justice. Dr. Johnston is a first-generation college graduate, and he shows students how success can be achieved through hard work, dedication, and attention to detail, such as communication with professors and the administration. He's an author, a reviewer, an academic, but most importantly, he is a friend to ENMU students and champions their success, and he truly lives his theme this year, one Eastern, one family, and one detail at a time. Please join me in welcoming Dr. James Johnston.
Thank you. Thank you, Judge, and what a great opportunity for our campus and for the university. To you. Sure. My apologies, I did not hit my mark before I started to speak. Welcome to Eastern New Mexico University. I have the honor of serving as the chancellor of the system and the president for the Portales campus. And we are honored to host the New Mexico Supreme Court and its Rule of Law program for 2026. This is a great educational program and opportunity, and certainly a good fit with our mission as an institution of higher learning. As I often explain, the role of a university is to teach students how to think, not what to think. Helping to bring programs like this to our campus and our community is a critical part of the education process and what we do as a university. At ENMU, we not only worked to be an important higher education resource, but a good community partner. We know that New Mexico is a rural state, and even as such, Portales is a little off the beaten path. So we appreciate the effort and resources that it took to bring the entire New Mexico Supreme Court process and operation to our community. So on behalf of ENMU, I want to thank all of those that put in the work to do so. I welcome many of our special guests today, but I also want to just give a quick special shout out to our former Justice, Chief Justice, and forever ENMU Greyhound alum, Edward Chavez. He remains engaged with ENMU, and I had the privilege of hearing him speak here last year. Yeah, thank you. I'm a couple more ENMU alums here. It's great to see so many engaged throughout the state. Each time I travel to Santa Fe and meeting and talking with so many wonderful alums and so many successful alums. I'm sure that we are all familiar with our civic duty to participate in the lower courts and the judiciary process when called upon to serve as jurors, and many of us have seen that level of the process. This program and event affords us the opportunity to see firsthand the New Mexico Supreme Court, the state's highest court, in action in fulfilling its role in the judiciary process. We've all studied and understand the roles of the branches of our government and know that through its rulings and interpretations, the judicial branch provides a place where we as individuals can seek a resolution if it is believed that our rights have been affected. Further, by deciding legal cases based on Constitution and established laws, courts help define the limits of government power and protect our individual liberties. But it is through this unique opportunity that we see this process at work, that we witness the rule of law being upheld. It is my honor to welcome Chief Justice Thompson, also recognized for his efforts in judicial education, and the justices of the New Mexico Supreme Court, to Eastern New Mexico University, and extend our thanks and appreciation for bringing the Rule of Law program to our community. Thank you all for being here.
At this time, I would ask everyone to please rise, and we will call court into session. Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Good afternoon, everybody. You may be seated. Thank you very much. Well, good afternoon, and before we officially open court, I do want to tell you how pleased we are as a court to see all the students out here today to learn about the rule of law and the vital role that the judiciary plays in our democratic society. Civics education. They train us in the law, but not mics. The first part of the speech was the best part. You want me to start over? No, I won't. Thank you very much for being here. I have a couple preliminary comments, and then we'll go ahead and open court. I want to thank you all and all the students and teachers and chaperones that came with you today to learn about the role of the court in our democratic society. It's important. Civics education is important to this court. It has been a top priority for a very long time. Part of that priority is this rule of law program where we go out to the communities in our state. We know we are a big state, and it's a big ask to have you all come to Santa Fe and watch. And we're just thrilled and honored to come to your community. And as an example, and I want to thank the state's attorney and the public defender for appearing today. Today, we're honored, I think this is probably, of the 6 programs we've had, the largest one. We have 600 participants today. I told folks we were interviewing in our courthouse, our 1936 courthouse in Santa Fe. If you ever have a chance to come, it fits 70. And on a big case, we'll fill the courtroom. We'll have some overflow. We certainly have not had a size 600 students before.
Many of you are live. Some of you are streaming, and welcome to those that are streaming. We make this program, we actually record it. And so if you don't have an opportunity to see it today, you'll have the opportunity to see it in the future. I want to welcome a few schools, Clovis High School, Texaco, Tularosa, Clovis Christian School, Yucca Middle School, Portales High School, Cloudcroft High School, and the New Mexico National Guard Youth Challenge Academy. And of course, Eastern New Mexico University. And you will hear from a proud graduate during the time that the court deliberates. Online, we have, I want to say hello to Mandela Magnet School in Santa Fe. I have last week had the opportunity to go speak to them about this case. Ruidoso, Digital Arts and Technology Academy, Early College Academy, Silver, High School, Pecos Middle School, El Camino Real Middle School, and New Hope High School. I'd like to thank Chief Judge Donna Maurer, judge in your community, her CEO Kevin Spears, and the entire team from the 9th Judicial District for their leadership in bringing today's events to Portales. We also appreciate our partner for the 2026 Courts Rule of Law program, Eastern University. Specifically, we recognize the contributions of ENMU Chancellor Dr. James Johnson, who you heard from, Dr. Chelsea Starr for hosting the 6th Annual Rule of Law program, and special recognition to ENMU Regent and Curry County Manager Lance Pyle and the NMU administration for making today's events possible. If you will join me, we normally don't applaud, but I want to give a special round of applause for all of the NMU Greyhound students and alumni here today. I'd like to recognize several local public officials. We had the honor to speak with Senator Pat Boone, District 27, Michael Davidson, the mayor of Portales. I want to thank the sheriff for his cooperation in today's event, Michael Brockett, City of Portales Police Chief, and the officers here today, Chief Christopher Williams, Tobacco County Magistrate Josephine Cones, Curry County Magistrate Judge Dussin, Curry County Magistrate Judge Whittington, and Curry County Sheriff Michael Brockett. We'd also like to recognize other distinguished guests from the 10th Judicial District. We have guests from the Law Office of the Public Defender, the 9th Judicial District Attorney's Office, the Roosevelt Law Center, and Larson and Mender Law. Finally, we could not do any of this without our excellent staff at the New Mexico Supreme Court and the Office of Administrative Courts. I want to thank them personally for holding this court off-site, and our Supreme Court Law Library team for providing teachers and students with a case synopsis and lesson plans. After today's argument, we will recess to deliberate. Each side will have about 30 minutes. In the interim, we are thrilled to have Justice Chavez here, who's a former member of the New Mexico Supreme Court and a graduate of this wonderful school. And he'll have questions and answer session with the students. A couple small reminders. Critical to our proceedings are respect and professionalism. They must observe silently without disruptions. Argument itself will take about an hour. And note taking is permitted with pencils and papers, but no photographs, please. With that, I finally want to recognize, it's important to me to recognize wonderful groups of colleagues that I work with on a daily basis. Senior Justice Michael V. Hill, Justice Bacon to my left, Justice Vargas there. Very honored to work with them on a daily basis, and I thank them for making this commitment to come down here today. Justice Zamora sends her regards. With that, counsel, we're about ready to proceed. All right, well, we know these attorneys, and we know we have a wonderful opportunity to hear from you today. So with that, I will ask my clerk to call the court, please.
All rise.
All right, thank you. You may be seated. We are here in State versus Mendez, S-1-SC-40404. May I have entry of appearance from counsel? All right. All right, thank you for counsel. You may proceed. Ms. Parquette, I believe you have 25 minutes, 5 minutes rebuttal. All right, you can proceed to the podium.
May it please the court. For nearly 39 years, New Mexico has followed the approach set out by this court in Fuson. When properly applied, it is an efficient and effective means of upholding a defendant's right to a fair and impartial jury. However, it only protects this right and the integrity of the subsequent trial as a whole when it is followed. The problem in this case is not that the Court of Appeals erred by applying Fuson. It's that the Court of Appeals did not properly apply it here. So I want to start by talking a little bit about the history of how New Mexico ended up with its current approach. As noted in Swain, the peremptory challenge has very old credentials. It goes back to the Middle Ages in England, colonial times in the US, and territorial times in New Mexico. Its historical significance is why it's been considered a substantial right, or to quote this court in Fuson, one of the most important rights secured to the accused. So leading up to Fuson, our mechanism for protecting the peremptory right was one that was commonly used at that time and is in fact still used in some states today, including Iowa and Florida, Hawaii, and Massachusetts. But essentially it was where a for-cause challenge got denied, the defendant used a peremptory against that juror, then used all of their peremptories, and to establish prejudice they had to show either which juror they would have struck or they had to show that a biased juror was seated. So that was...
Counsel, why shouldn't we, I think as the state argues, simply decide that because your client had peremptories available to him, that they could have waited and used one of their peremptories against this particular juror, and that opportunity kind of takes care of the problem?
They did use the peremptory in this case against the juror, but it doesn't solve the problem because it takes away a right to which the defense is entitled. Under Rule 5606, Section 38514, and I would argue as an extension of the right to a fair and impartial jury, peremptories serve a discrete purpose. So pushing them into for cause by saying, oh, it's okay that the court didn't for cause this person when they should have because you got to strike them anyway. That takes away the additional layer of protection and the purpose peremptories serve. For cause challenges are aimed at overt bias. That's very clear. Peremptory challenges is related to the hidden bias, which we're not always able to tease out because people won't always feel comfortable admitting it, or perhaps they're not aware of it, but we don't have the resources to always tease it out. So you lose that.
Would your client have used a peremptory against later individuals in the veneer panel?
I think the record indicates that they would have because certainly they were striking people for reasons similar to Juror 22. So I think this record does indicate that. I don't know that we need that. Mm-hmm. I think our approach is cleaner, and we essentially are saying we're going to presume prejudice under those circumstances once you've exhausted your peremptories because you've lost this right that's necessary.
But do you have a right to let's assume, do you have a constitutional right to peremptory challenges?
Not under the federal constitution.
What about the state?
We have not recognized it under the state as of yet.
So if they took away peremptory challenges, where would your argument take you?
Well, we would continue litigating other related issues. So Arizona actually did get rid of peremptory challenges, and in doing so, they had to adopt a slew of other procedural protections that we don't have.
So a peremptory challenge, as I understand it, is you don't have to give a reason. You just don't like the way they looked at you or whatever the reason. You don't have to give a reason. You just say, I strike juror number so-and-so. Is that right?
Yes. And that's to ensure that hidden bias doesn't infiltrate the jury, right? They are striking people because obviously if it's a good juror, they want them on the jury. So they're striking a juror because they're concerned this person is biased against me. I may not be able to spend 30 minutes arguing with them to get them to admit this. And we don't want a process where where we have to argue with every juror that we think is biased.
But you do want a process in which you ask the questions that elicit why a cause strike should have occurred, right? I mean,
Yes.
and that's part of this case, which is the judge has to have the information necessary in order to decide cause or not, and that's why it's important to have those questions asked.
Yes, and this is not to diminish the importance of voir dire. It is a vitally important process. It's simply to say we do allow there to be time restrictions, and we are not going to, they don't want the attorney, I don't want to say picking on one person, but singling somebody out. That's uncomfortable for everyone. So instead of doing that, sometimes it's just easier to say, I think they're biased. I don't think I'm going to be able to prove that. They've been rolling their eyes at me. It can be any number of subtle things, but basically there are good reasons for striking them. As I said before, if this was somebody that they thought would be fair and be good for them, they'll keep them on the jury. They have every interest in doing that.
And counsel, just because we have a lot of people here and online, and not everyone might be familiar with the facts of the case, what is the bias you are alleging occurred with this particular panel of the veneer, or member of the veneer?
Right. So it was that Juror 6 expressed repeatedly that he would defer to law enforcement and was biased against the defendant going into the trial. Initially, he had said, after there was some back and forth during voir dire, a few of the people said, well, we think he's here for a reason, but it's not necessarily guilt. They said he just could want to get this taken care of, or they could have the wrong person. They were throwing out instances of why it might not be him. And Juror 6 voluntarily spoke up and disagreed with everyone and said he obviously has a reason to pull him over, and we wouldn't be here if they didn't have enough evidence that's proof. On further questioning, he said he assumed Mr. Mendez did something, and then when the defense counsel asked if this would weigh on him in deliberations, he said that it would because Mr. Mendez did something.
And was there any effort by the district attorney in that case to rehabilitate?
No.
jury?
And that's true even after the second round of questioning. That was really the focus in the Court of Appeals because they refused to look at the first response. But at the second one, he directly said in response to a question, okay, so you think you would give law enforcement testimony more weight than someone else? He said yes. So I think his bias was stated. He indicated that this would go to deliberations, and there was no effort by either the court or the state to rehabilitate him.
So, counsel, my recollection was that the reason he said he would give more weight to law enforcement was because law enforcement had training and experience that maybe the jury didn't have or others didn't have, and so it was appropriate to give law enforcement a little more weight. Why is that wrong?
Well, first, it was actually Juror 13 who initially said I would give them more weight because of their training. He said he agreed with Juror 13, but then she directly asked, without mentioning the training, so you would give more weight to law enforcement, and he said yes. In addition, I think there are actually instances in the briefing in the Slater case out of Florida and the Paul case out of Louisiana where they made very similar statements. The jurors who were supposed to be struck said, well, I would believe them because of their training. I would believe them because of their experience. I mean, you can give them more credit for any number of reasons. I just respect authority figures more. It doesn't really matter. You are still going into this process favoring them inherently.
So would it be wrong if we were to decide that what he was saying was that I'm giving them more weight because of their training and experience? Are we still required, are you still arguing that they should be stricken for cause?
Yes, I still think that does make them biased, but I think it's not just that in this case. Because if you look at it in the context of his other statements, he's very clearly going in favoring law enforcement just across the board and against the defendant. I'm sorry.
What if the juror says, I believe law enforcement? Is that bias?
I think if they say it would impact their verdict, yes.
I'm sorry, what was the answer? If they say it would what?
If you say it would impact their verdict, if they're going to go in and just say, I believe law enforcement, then they're going in, prejudging the situation.
But that second part wasn't added to this juror's statement. And the reason I ask is the jury can be presented with two sets of facts and then weigh the credibility. Is it enough, it seems, you're arguing, that if a juror in voir dire and public defender or the defender stands up and says, do you believe what they say to be true? Yeah, I believe law enforcement. Would that require a cause strike?
I think it very well could, depending on the circumstances of the questioning. That's part of the entirety of this argument, is you do look at all the circumstances surrounding the questioning. You don't want to look at it in isolation as the Court of Appeals did.
Did the jury have the facts about the case in front of it? And does that matter? So it turns to the question of, if the language was, the officer had a reason to pull him over. In this case, the defendant wasn't actually pulled over, was asleep in the car, as I understand. Does it matter that, well, let me ask it two parts. Were they given the facts, and does it matter the facts of what the juror represented and what the actual facts of the case were?
They were not given the specific facts. We generally don't let them get into the facts during voir dire. They were given the charges. They had been told about the nature of the charges already. So they did have some idea this was an aggravated DWI at that point. But I don't think that really matters. If they're making assumptions about the facts, and especially if those assumptions are, I think they did something that is going to impact me, and I'm going to believe law enforcement. When they make that series of statements, it's very clear they're going in and they're not being fair and impartial, and they've indicated to us that is going to impact them in deliberations. So I think at that point, they have made their position clear and they should be struck for cause.
Counsel, would it make any difference if this juror was asked, can you set aside those opinions?
I think it potentially could, but I don't feel like it would overcome it in this case. I say potentially.
Was he asked if he could set those aside?
No, he was not.
Okay.
But to the extent he was asked if this would impact him in deliberations, and had already sat through the state's voir dire, during which they spent a lot of time saying, and you can set this aside, and you can set this aside, and you can, I think that they understood them being asked, is this going to bother you in deliberations, and saying yes, that they weren't going to set it aside. But no, they weren't asked that exact question. But also in terms of like whether rehabilitative questioning can overcome statements spontaneously made by the juror. There's a lot of hesitation in courts to say, well, their spontaneous statements should be overcome by this very detailed, careful questioning by the court or the state. And I think you see that in DeVore, the Montana case that's talked about in Sims, one of our cases, is talked about in Overton and Rhymes, both out of Florida. So there's a number of cases talking about how the limits of rehabilitative questioning.
So can I ask you another question?
Yeah, of course.
So how do you answer the state's argument that, look, the guy was asleep at the wheel, in his car, he admitted to drinking, he took a blood test or a breath test, it was weigh 0.2 something. Why are we even talking about this? The man was obviously guilty. This creates just a rebuttable presumption, and the facts here speak that this presumption, it didn't matter. There's no presumption here because the facts are so strong. What's your answer to that?
The rebuttable presumption doesn't refer to the facts of the case. The rebuttable presumption in this context is something like they were offered another peremptory. So to replace the one they lost, it goes to the integrity of the jury selection process itself. And you see this, because again, we adopted this approach, and it was not new to us. It was an approach, I mean, it was new to us. It was not new to the country. We adopted an approach used elsewhere that is still used elsewhere. It is used in Louisiana, Montana, Vermont, New York, Pennsylvania, Virginia, Kentucky. It is a commonly used practice. It is not based, you can't fix it by saying that they're super guilty. In fact, the only court I know of to have done that was Montana, and they explicitly said that's not working for us because this isn't a trial right. This is one that precedes trial. It affects the framework of the trial, so it needs to be protected in and of itself. So the harm done is the harm done to the selection
Because
process.
the individual is innocent until proven guilty.
Yes,
And
yes.
so you could have a mountain of charges and doesn't amount to a hill of beans, but it really doesn't matter because they haven't been found guilty yet. So the mountain of charges is just words on a piece of paper at that point.
Right. So the harm needs to be, the focus of it also needs to be on when it occurs and when we can still fix it, as opposed to trying to fix it later on at trial. And none of our cases have ever applied it in that manner, and none of the cases in many of the other jurisdictions applied it in that manner.
What's your response to the state's argument that the Tucson case, I think that's how you pronounce it.
I tried to Google it.
I know. But that case should be overturned, that it is, in large part, I think what the state's argument is that it's unworkable.
So first off, I don't think it needs to be overturned at all.
Yeah,
Rivera was very clear that, quote, states are free to decide as a matter of state law that a trial court's mistaken denial of a peremptory challenge is reversible error per se. They were inviting states to continue using their per se approaches. In addition, there's no compelling reason to depart. It's not unworkable. This is not proven to be a windfall for defendants in New Mexico, and even the Busby court, in talking about retaining theirs also noted this hasn't proven to be a windfall. We're not reversing all the time, and to the extent we are, it's a necessary reminder to courts to scrupulously uphold their duty to do for cause challenges and not take challenges away from defendants. It's also not a remnant of an outdated doctrine. New Mexico and several other states continue using this. This is an actively used doctrine that some states have even chosen after trying other things, and you can look at the Good case from Montana which talks about their experience.
Counsel, what about the argument that the state makes that the rebuttable presumption that arises once a defendant uses all their strikes and a for cause is denied that they think should have been granted can be rebutted? The state's argument is that the ability to rebut the presumption is basically a fallacy. It doesn't exist. You can't really rebut. There's no way for them to do it. And that's why we should get rid of Fuson. How do you respond to that argument?
Well, you can, in theory, rebut it if, of course, the court says, actually thinking on it more, I'm going to give you an extra peremptory, or if there are, I think, there's some mechanisms, some statutory, or not, excuse me, rule provisions that say you get 2 extra peremptories under these circumstances, and if you have that and you say you don't need it, obviously I think you've rebutted the presumption that it's decreased or impaired your use of your peremptories. But again, I don't think this is a trial error. This is an error that affects the integrity of the trial. It is most strongly associated with the right to an impartial jury under Article 2, Section 14, but it also has implications for the fairness of the resulting trial and of the defendant's exercise of rights at trial. And you see Jonas out of Iowa, and the Good case out of Montana, and the dissent in Clark out of Colorado. They all talk about how this impacts the framework of the trial, and it does so in nuanced ways. If a defendant ends up with a number of people on the jury who have expressed a real desire to hear from the defendant, that could impact the decision to testify or not. If they've had a number of people who are very nervous about certain kinds of prejudicial information, that could also impact their decision to testify or to present other kinds of evidence in their defense.
To the senior justice's point, I want to
Okay.
I want to understand your position. It's the constitutional right to an impartial jury, correct?
Yes.
That we're talking about.
Yes.
There is no constitutional right necessarily at this point to either a preemptory, which are, for audience, preemptory is strikes you get voluntarily, you don't have to say why. And then the cause strikes, which the judge is going to strike. You technically got the jury you wanted. This individual was struck, right? There was a preemptory exercised. There's nothing in the record before us that says that the juror that eventually sat on that panel had any bias at all, meaning your client did not get the jury they chose, and that's where the constitutional right lies. Why doesn't it end there?
Well, I mean, to the extent that he got the jury he chose, that's not entirely true. The defense was denied an opportunity to use another peremptory, so they were denied an opportunity to further shape the jury that they ultimately ended up getting.
But that would have been the next juror in line, right? But there's nothing in the record that juror that eventually sat was biased or prejudiced.
Well,
it's just violating the right to strike that jury? Is that what you're asserting?
No, I mean, they didn't identify the juror they would have struck because under Fuson, we don't have to. That was a requirement under Martinez, which Fuson overturned. So we went from having to identify which juror we would have struck to a streamlined approach where we just assumed once they used all of their peremptories, they had lost a peremptory and the harm was done. So that's why there's not this identification, because our rules didn't require it.
And isn't that the reason maybe for what the concept, at least, I've not seen it in practice, but the concept at least that the judge could grant some additional peremptories to kind of cure the problem if they said, on second thought, maybe I should have struck this guy for cause?
Yes. Yes, they can offer an additional peremptory in those circumstances, and that does cure it. And that's just out of an abundance of caution. And frankly, that is what we want to encourage, is acting out of an abundance of caution. Some of the cases and the courts struggling with this issue and deciding on this approach or a similar one, they noted the worst thing that happens if you strike an impartial juror is you replace them with another impartial juror. But if you fail to strike a partial juror and either the peremptories get exhausted or some other partial juror ends up on the jury, the harm done to the entire process is unreviewable generally, but it's also undoable. We've tainted the right to a fair and impartial jury, which is a right in and of itself. We tainted the fairness of the proceeding, and we've potentially impacted the trial in other ways. And unless we want to start investigating the ways we've impacted it by opening up deliberations to attacks by showing bias afterwards, we have to keep our focus on what happens in jury selection rather than at the trial stage. And the Court of Appeals here just simply did not apply these rigorous standards adopted by this court in Fuson. As I noted, they focused on one of the statements made, but did not focus on the others. And that's particularly telling as being contrary because it's inconsistent with cases predating Mendez, and that includes this court's opinion in Romero, Johnson, Sanchez, Rackley, Holtzhoyt. All of those look at the entirety of the statements being made, the entirety of jury selection. But it's also inconsistent with cases following Mendez. After briefing was completed in this court, the Court of Appeals issued an opinion in Fulton, and that's 2026 NMCA 025, where they expounded upon how important it is to look at the totality of the statements and to look at everything in context. So they're very clearly not applying this well-established standard in this case that they then go back to after this case.
So,
Sorry, go ahead, Senior Justice.
if I understand what you're saying, is that the lawyer at trial said, I contest juror number 6 because juror number 6 is biased and prejudiced.
Yes, in essence, yes.
And you're saying that what we should look at is what is the evidence that shows that?
Yes, and we look at
And
all of
not
their
separate and
statements.
divide the way the Court of Appeals did.
Right, exactly.
Counsel, can you cite a case to me, because I'm trying to reach into the recesses of my memory, where the state was able to rebut the presumption of prejudice once there has been an establishment that there was, that the juror demonstrated that they could not be fair and impartial?
I can't, but that's partially because we have so few cases where we've
Yeah, I was
actually
trying to remember one and
reversed.
can't.
No, but we, almost no cases up to Holtzoy reversed a defendant's conviction under Fuson. So as I said, it's not been a boon to defendants. But no, I can't think of a New Mexico case. I think in my research I did find one where a court later said you can have another peremptory, and then they said that rebutted it. But that was, I would have to go through the recesses of my mind.
Thank you, Counsel. Your time is up. Thank you. Thank you for your presentation. Mr. Thomas, for the state of New Mexico, you have 30 minutes.
Thank you. May it please the court. Defendant was tried by an unbiased jury and convicted based on evidence that can be described as overwhelming. Defendant was found sleeping in the driver's seat in a vehicle with the engine running at a stop sign in the middle of the day in Tularosa. The officer who made contact with defendant and had to wake him up immediately smelled the odor of alcohol. Defendant admitted having recently drank alcohol. This was all caught on the dash cam video.
But counsel, none of those facts were established at the time of voir dire. I think that's a fair statement because the jury hasn't been impaneled yet. So I'm not sure, at least speaking for myself, I'm not sure I care so much about what the facts related to the ultimate conviction were. I'm more concerned about the facts surrounding juror number 6.
Yes, Your Honor, and that actually leads to something I was going to touch on anyway. I think Juror 6's statements really taken in context do not show bias, and I'm certainly prepared to talk about, if the court certainly wants to, and I'm willing to talk about, let's assume Juror 6 is biased, what's the remedy? But if you look at Juror 6's statements, and I'm trying to do this from memory because I don't want to just sit here and read. His first statement was something to the effect of, he said, well, the officer must have had a reason to pull him over. And I can't remember which justice had asked the question. I think it was Justice Thompson. Hit on the point that the state tried to make in the answer brief, which was that at that point, the jury only knew that the person was charged with DWI. And it's consistent with any of the jurors being impartial for the jurors to say, well, I don't know the facts of this case, but if he was stopped for DWI, the officer must have seen him do something, whether it was speeding, almost hit a curb, almost hit a vehicle, something like that. And that's a reasonable assumption that the jurors can't be faulted for, because at that point, all they knew was DWI. And the stereotype people think in their head is, from watching police shows, cops, is that, oh, the person was driving, I saw him almost hit a curb, I turned on the emergency light, stopped him. Well, a juror can make that reasonable assumption, but still objectively say, I'm willing to be fair and listen to the evidence. So when the jurors...
But that didn't happen in this case.
Well, sorry.
That didn't happen.
I'm sorry?
That did not happen. He was not asked, can you set that aside and be fair and impartial?
Well, that's true, and I want to touch on that in a second, but certainly the point that the state was simply wanting to be there as a baseline is the fact that the jurors can't be faulted for saying, well, the officer must have seen him do something. He must have had a reason to pull him over. And that can be consistent with still being impartial in the sense of I'm willing to hear the evidence and go in unbiased.
Mr. Thomas, can I ask you a question, please? Sure. Does the judiciary, do courts have an interest in having a fair and impartial jury hear a case?
Oh, sure.
And if that right is violated, what is the remedy?
That I think was sort of hit on the head earlier, which was that the constitutional right is to an impartial jury, and as long as you get to
my question is not to the defendant's right. Does the judiciary, does the judiciary have a right to have fair and impartial jurors hearing cases and deciding cases?
Oh, definitely, as a matter of systemic integrity, sure.
Okay.
And another thing I wanted to touch on, and I'm glad these questions are leading me to topics I wanted to get to anyway. One of the things is that it is the defendant's duty, of course, to show bias, because as we know from the Romero case cited in the answer brief, the juries are presumed to be impartial. I cited it in the answer brief, Romero, paragraph, I don't know if I can find it really quick here, but in paragraph 7 of Romero, this court stated that we presume that a jury selected from a fair cross-section is impartial. So then it leads to the question of, well, whose burden is it to show that juror is biased? Obviously, it is the defendant's burden, but what I'm getting at here is, I'm not faulting the defense counsel or the prosecutor here, but one of the justices hit it on the head. Someone should have just come out and asked Juror 6, can you be fair and impartial? And the reason why I mention that is because of a couple of things I just want to point to. First of all, in Fuson, Justice Ransom noted in his dissent, Justice Ransom wrote, I do not want to dilute a great deal of discretion by holding that a lack of certainty and possibilities skillfully elicited in voir dire shall require that the court dismiss prospective jurors. And then Justice Ransom sort of rhetorically asks, is not partiality always a possibility? But kind of leading to that or following up on that, if you look at Romero, paragraph 18, they talk about in that paragraph 18, this is what the court said. This court. The court said, further questioning would have been necessary in order for the statements to rise to the level of actual bias. However, defendant chose not to avail himself of that opportunity.
But here, Mr. Thomas, the facts are different. The defense counsel got up and said, if the state presents a bunch of evidence to you, are you just going to believe it because we wouldn't be here if that hadn't happened, or are you going to weigh it? And several witnesses came back and said, oh, I'm going to weigh it. I'm going to look at it, and it's up to the jurors to make the decision. And juror number 6 came back on his own and said, I disagree. I don't agree with all those people who just said, I'm going to weigh the evidence, because we wouldn't be here if they didn't have enough evidence to prove him guilty. Why do we even need to have that question asked? Can you be fair and impartial? When he interrupted everybody and said, I don't agree with any of this.
Well, you're hitting on a very good point, Justice Vargas. If we ignore for now the first statement where he says, I'm assuming that officers saw something that caused him to pull him over. The second statement, which was really which is what was given as the reason for cause in the district court, even the second question was phrased, and that's why I read the part from Justice Ransom and Fuson about sometimes an attorney can sort of skillfully elicit questions from a juror that it needs to be taken in context. So I guess the answer to the question is, when that juror 6 said, well, he was asked, if there's a conflict in testimony, would you believe law enforcement more because of their training and experience? So I think that's a little different than just saying, would you believe law enforcement more? Because it was based on experience and training, and if there's a conflict. And here, there ultimately was no conflict because, well, the defendant, of course, has no obligation to present any witnesses or testify. It was just Lieutenant Blanton and the intoxilizer key operator. So there was not even a conflict where a juror might have to say, well, the defense and 3 witnesses said this, the officer said this, I have a conflict.
To Justice Bacon's point, that's after you've heard all the testimony. How does that help us when we're trying to decide whether we've impaneled a fair and impartial jury?
Well, and I think what the Court of Appeals was trying to get at here, this is the way I read paragraph 24 in the Court of Appeals opinion. The Court of Appeals says that Juror 6's statement does not establish express bias because it is not an unequivocal statement that he could not be fair and impartial. Then they cite Romero. Okay. And then later in that paragraph, and I believe
he doesn't make that unequivocal statement because the state failed to even ask him. And so to me, that's a problem that the state has to own here, is that that it's certainly not the defendant's burden to say, can you be fair and impartial at that point? And you're almost flipping the burden to defense counsel to ask that, which undercuts their case. It's really up to the DA to ask that question. And so I'm very concerned about kind of switching that burden around.
Right. And I understand Justice Bacon, and certainly Holtzoi does talk about the fact that there can be rehabilitating statements that have to be sort of looked at in context. And certainly that's sort of what I was getting at earlier when I mentioned that ideally, and I'm not faulting the prosecution or the defense attorney, but if the juror had been asked, it certainly would have clarified the record. Mm-hmm. But in paragraph 24 of the Court of Appeals opinion in this case, I believe that's sort of what the Court of Appeals was getting at, which is that the Court of Appeals here wrote, defendant has not explained why the statement at issue was sufficiently problematic, and then they put dash, standing alone and without further factual development through voir dire questioning to require the district court to disqualify juror 6. So my only point is I think there's a real question whether juror 6 said anything that really amounted to actual bias, but certainly in a minute we can get to the point of what's the remedy if he was biased.
Mr. Thomas, what the Court of Appeals is saying that you just quoted is referring only to the second statement made by the juror, because the Court of Appeals refused to consider the first question. So, but would you make the same argument when you combine both statements and consider them both together?
Yes, I would, and I respect, and the state, of course, understands that during voir dire, we're just looking at whether jurors can go in being impartial. They don't know, of course, all the facts. It may be that 2 days later or a day later into trial, the jurors realize, wow, there's a lot of evidence here. I'm still being open about it, but there is a lot of evidence here that I didn't know about when I was being asked these questions during voir dire. But I would say the state's position would be yes, still, that it does not amount to bias, because a juror saying, well, he must have done something to cause the officer to pull him over, that's consistent with a view that I'm going to be impartial and listen to the evidence, because it's only later on they realize, oh, the officer didn't even have to pull this person over. He was sleeping in his truck in the middle of the day, which obviously, yes, goes to guilt, but it provides context for why a juror might say, I'm going to be impartial, but yeah, to be honest, I'm assuming he hit a curb or almost hit a car. Something caused the officer to notice this driver.
I'm curious about sort of subset of senior justice questions, there's two statements by the juror, and what the obligation is on defense counsel to tell the court the exact statement that they believe is driving the bias. As a trial court, you're sitting through a panel of maybe 50 jurors, and you're trying to remember what everybody said. And then the objection comes in, juror 6 is biased because they give more weight to law enforcement. Is there more required, and does that enter your argument about, in either preservation or otherwise, about what the defense attorney alerted that judge to with regard to the particular statement? Or is it enough for defense counsel to say, juror 6 expressed bias towards law enforcement?
Well, ideally, and again, I know trials happen very quickly. I'm not going to fault a trial attorney in the heat of voir dire for maybe not asking articulate questions. I'm an appellate attorney, and I understand that's tough at trial, but I think the best answer to your question would be that, yes, ideally, it would have been ideal if had the defense attorney or the prosecutor attempted to rehabilitate juror 6 by saying, well, juror 6, but do you believe you can be fair and impartial in judging the evidence you're going to hear later on today? And clearly, if juror 6 had said, I don't think I can be fair, fine, that's clearly, he's probably almost certainly going to be justifiably removed for cause. But
I guess my question is it enough for defense counsel to say, juror 6 said, at this point, we assume defendant had done something where it may go to training and experience, as Justice Vargas solicited, and not more of what juror 6 said, because was more specificity required of the defense attorney as to the particular statement?
Without faulting the defense attorney, I think more specificity would have helped. I think one of the justices sort of hit it on the head earlier when one of you mentioned that obviously to the extent you can go in a little bit more detail, it makes it easier when you're asking that juror questions. It makes the record clear, so the district judge can more clearly say, I'm going to remove that juror for cause, or I've heard enough, you've had plenty of time to ask this juror questions, I don't believe you've established cause. Of course you can use a peremptory, but yes, more detail would have helped. I don't know if he done something was enough, to be honest.
If he answered, I believe, who believes law enforcement? I believe law enforcement. Do you believe that is an expression of bias?
I don't believe so, but that might be a little closer, but I think here it's a little less of a closed case because of the fact that even the defense attorney said, well, if there's a conflict in testimony, would you believe law enforcement more based on their training and experience? So it was hedged a little bit more.
But that's not really what Juror 6 said. I mean, it's the defense counsel kept asking, can you weigh the evidence as presented and then ultimately decide the case? And going to Justice Vargas's point, Juror 6 popped up out of the blue and said, I'm disagreeing with everybody else. They obviously had a reason to pull defendant over. We would not be here if they didn't have enough evidence to prove him guilty. That, to me, is a pretty bold statement by juror number 6, and so I'm not sure what else the defendant had to ask at that point. Certainly think the state had an obligation to say, well, can you set that aside, or you're going to get a bunch of instructions from the judge that tells you blah, 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 and that you have to listen to the evidence as it's presented and in that way decide the case, and none of that happened. But I'm not sure this idea of putting it back on the defendant, I mean, the defendant almost rang the bell here with that statement, and I think the inclination by the public defender at that point is, I'm not going to touch this little pot of gold. And then also the fear of potentially, poisoning the pool. And so there's all these decisions, rapid fire, going on here, and I'm really not convinced that the defense had to do something more.
And I understand that, and to appellate defense counsel's credit, she did note in a footnote that toward the end it was a little hard to hear what Juror 6 was saying, something about to prove him guilty. Subject, of course, to the court's questions, I only wanted to spend maybe another minute on the bias issue, then I wanted to get to the remedy. But one case that's worth noting, I don't believe I cited it in the answer brief, I may have, but State v. Johnson, 2010, New Mexico Supreme Court 016, in paragraph 31 to 32, in that case, they said there was no error in refusing to dismiss jurors. And that was interesting in that case because from paragraph 32, they talk about jurors 28 and 35 indicated the trial would cause them to think about the murders of their loved ones, which right there, if you stop, kind of makes someone think, oh, they're going to be biased. But both also indicated that they would be able to be fair and follow the instructions of the judge. It goes to the point that, yes, a little bit more clarity in the record in line with, say, Holtzoy, which talks about you've got to look at were they rehabilitated before or did they say something and then they were rehabilitated after, would have been ideal. But at this point, subject to any questions, I'd like to talk a little bit more about the remedy. Although the state doesn't believe Juror 6 was biased, clearly we understand that basically what I'm getting at is that in any case where if a defendant believes that juror X is biased, they have a choice. They can either use a peremptory to get rid of that juror and hopefully end up with an unbiased jury, as we believe there was an unbiased jury here, or of course a defendant can take the risk that, well, my view that juror's bias will be upheld on appeal, but that's taking a big risk because on appeal, if the appellate court says, sure, the appellate court may say, yes, we believe that juror should have been dismissed for cause, so defendant, you get a new trial. But the defendant takes a big risk because of the fact that on appeal, if the appellate court says, the record's not real clear, or we just don't believe that quite rises to the level of bias, well, you didn't excuse him for cause, he was on the jury, we don't believe he was biased, your conviction stands. So there has to be some strategic use of peremptories there. But here, let's just assume Juror 6 was biased. The point is, the problem with Fuson is going to be that a defendant is always going to want to be inclined to say, well, look, I used my final peremptory to get rid of this juror. Yes, I may have ended up with an unbiased jury, and there may have even been overwhelming evidence, but because I used my peremptory to get rid of someone, there's kind of a loggerheads between the fact that there may be almost an admission that you did receive an unbiased jury, but Fuson says, well, you used a peremptory to get rid of that juror, you get a new trial. So Fuson We believe it establishes a rebuttable presumption, not irrebuttable, and we believe here the overwhelming evidence would rebut it. But the more foundational problem with Fuson is, of course, that in 2000, the United States Supreme Court said they basically overruled that part of Swain v. Alabama and said it's not a federal constitutional issue. States, of course, are free to do what they want, but and of course, the Colorado case I cited in the notice of supplemental authority in January kind of explains the reasoning. And the Colorado Supreme Court, less than 2 years ago, acknowledging Martinez-Salazar, the 2000 U.S. Supreme Court case, said, yes, you're not prejudiced, even if you use your final peremptory to get rid of a juror that everyone later on agrees, yeah, maybe they probably were biased, because you ended up with an unbiased jury. So that's the main issue.
How would they be required to show that the individual that ended up on their jury was biased? And how would that be done?
Well, that's a good question, but that's why.
I mean, I can't see a scenario where I struck juror number, and we'll just use numbers. We have 12 jurors, 2 alternates, so let's just say juror number 18, we asked them a bunch of questions. That was wearing a law enforcement uniform, had the FOP hat on, and they ended up on the jury. They used a strike on the previous one, and they ran out, and now they ended up with someone that they can now assert, according to the record, created a biased jury. Is that a different argument, or do they have any obligation to show the facts with regard to that juror that ended up on the jury?
Well, if that other juror who ended up on the jury was biased, one would think that at some point they would have challenged that juror for cause. So I think part of this is an order issue. I mean, granted, ideally what will happen is the defense is going to try to establish as much as possible, jurors A, B, X, Y, and Z. We believe they're biased. We ask them a lot of questions. We want them struck for cause. Have that dialogue with the prosecutor and the court. But if the court ultimately on that record says, I don't believe he was biased, you would hope the defendant would have enough of a record to say on appeal, I ran out of peremptories. I had asked juror Z to be removed for cause. They weren't. I couldn't get rid of them with peremptories. So on appeal, I'm going to say juror Z who sat was biased. And I don't think that was established here as to juror 22, which I know the defendant kind of touches on juror 22, but I don't think there's even enough in the record to show that juror 22 was requested to be removed for cause and was mistakenly not removed.
But counsel, if peremptories are designed so that you can remove people on the jury who don't have this overt kind of statement, it's as the appellant's counsel described it, and I remember feeling this way as a trial lawyer. You've got a juror who's rolling their eyes, and that doesn't show up on the record, or their body language. We're all looking at body language and trying to figure out, do they hate me? That's what lawyers do during voir dire. And the body language is arms crossed, legs crossed, that kind of thing. That's really difficult to put on the record without completely alienating that juror. And that's what peremptories are for. And so the chief's question was really talking about cause, as opposed to that peremptory wit dance, which is a little bit different. So how would the idea, like if we were to follow the Colorado path and say you need to have something else, I'm not sure how we would prove that without making the lawyers witnesses, putting them under oath and saying, what was your thought process, which is sacrosanct. I mean, I just see this kind of host of issues there.
And I appreciate your clarifying. I think I understand Justice Thompson's question better. Thank you. I think maybe part of the solution is, and I kind of touched on this in the answer brief, this court could certainly say, okay, for all trials where jury selection starts after the day of today's opinion, if the court were to rule that way, maybe part of it would be, attorneys would be on notice that, okay, you can use up however many peremptories you have, but if you use up your peremptories, even to get rid of a juror that's biased, you're not going to have a remedy. So what that'll cause is them to be probably focusing really on the cause issue, trying to get rid of jurors for cause. But like you said, you don't want to challenge someone for cause, and then next thing you know, they're on the jury, and now they're thinking, well, this lawyer tried to remove me, and now I'm even more biased against them. But I guess part of that solution could be that maybe the statute or the rule would be, hey, we're going to change Fuson, but we're going to give you more peremptories, but you're going to have these more peremptories, maybe an extra 4 or 5 peremptories on the defense side, but you're on notice that you've got these extra peremptories, but that's it. After that, you better be strategic in your for cause and peremptory, Mr. Defense Attorney, because we're giving you extra peremptories, but it's on the understanding that Fuson's no longer good law. So maybe that's part of the give and take.
But what if this juror had said, I don't like police officers. I had a cousin that was convicted on the basis of a lying police officer, and I will never believe police officers. And the state has to use the peremptory on that person.
I would say that's just part of, I mean, that would be fair to the state too, meaning that the state would have to say, hey, we can let this person stay on the jury, but we know that's going to make it harder for us to get a conviction. But I think as long as each side knows going in what the rules are and how many peremptories they have, they're going to be strategic as best they can be.
The point, and I think you agreed, is that the courts have to have the respect of the citizenry, that the people that are deciding these cases on juries are fair and impartial. They can't believe that these cases are fixed by partial jurors. Otherwise, the judicial system falls apart. And what you're saying is, if I understand you right, is that if you look after the fact at who actually sat on the jury and after the fact of what the facts were, the fact that either side had to get rid of apparently a partial prospective juror means nothing.
Well, I think it's simply because the state's view of what, like, say, the Colorado Supreme Court recognized and what the Supreme Court recognized in Martinez-Salazar in 2000, which is simply that, peremptories are really a safety valve. They're a tool to help you get to an unbiased jury. And it's kind of, hey, we're going to give you these bonus strikes. You can just say, you don't have to say, I don't like the way the guy looked at my client or the way he looked at me, but we're going to give you those peremptories, but you need to use them strategically. But really the goal is, what you have a right to is to get to an unbiased jury. And if peremptories help you get there, that's great. But it shouldn't depend on whether someone's conviction is upheld or not, whether they ended up with 0 peremptories or 1, because it's kind of a strange thing when the ultimate issue is, were you tried by an unbiased jury?
So, I'm sorry.
Go ahead.
No, go ahead.
So if I use my peremptory on number 6, but I didn't want to use it, but now I can't use my peremptory on number 22. Haven't I been hurt in that way?
I would say it really depends on whether you could have shown that juror 22 should have been stricken for cause. Clearly, if juror 22, if you establish the record that 22 should have been removed for cause, then you've got a good appeal issue.
Not for cause, but because they were rolling their eyes.
Yeah, but I guess I would say that jury selection is not a perfect process. You do the best you can. I know there's jury consultants, and you do the best you can. But again, we go back to Romero, the statement that cited in the answer brief, that they're presumed, members of the community are presumed to be impartial. And it's sort of, the burden is for a defendant to show, hey, yes, they're presumed to be impartial, but this particular juror is biased against me. I want to remove for cause. Or I've got a couple peremptories left. I need to be strategic. I want them out of here.
But in order to write that rule, it's where I'm a little caught, especially with Fuson. I'm still not sure where the right is. The right is an impartial jury. There's nothing in the record that didn't occur. Does, in your view, Fuson, or if we were to write the rule, the appellant is arguing today, that we would now be creating a constitutional right in the strike, in the peremptory, instead of what I understand to be the fundamental principle, which is the impartial jury? What do you make, if this is a fair question, what do you make of the rule that the appellant's attorney is asking us to write today?
I think it's a little unclear, because it's unclear, are they saying that you have to end up with that you had at least 1 peremptory left Because obviously, if you have 0 left, the person's always going to claim, oh, I would have used it on this person if I'd had even one more. So it's a little unclear. That's why it's a little unmanageable.
If I suggested to you it was, if I can show bias with someone that was not struck for cause and I run out of preemptories, that is reversible.
Well, I would agree that if there's someone that really should have been removed for cause and they weren't, and you couldn't remove them because you had no more peremptories left, then presumably that person sat on the panel and you can show they were biased. And I essentially am done, subject to any questions. The only thing worth noting, and it was sort of touched on earlier by defendant's appellate counsel, is that really overruling Fuson would just involve going back to this rule in State v. Martinez, the 1981 NMSC 5. And that was the case where in paragraph 16, they say if there was error, it was harmless since there is no allegation that the impartiality of the jury panel was attached by it. So that was the rule in 1981. Fuson changed it, but then 13 years later, the U.S. Supreme Court decided it. So I think it's just fair to acknowledge that Fuson itself was clearly referenced numerous times, federal cases. Fuson just should be acknowledged for resting on federal cases that have since been overruled. But thank you.
Thank you, counsel. Thank you for your presentation.
Thank you.
Petitioner, 5 minutes.
Okay, I want to start by clearing up, providing a little more context as to why Juror 6 was biased. First and foremost, immediately after his initial statements about he obviously has a reason to pull him over and we wouldn't be here if they didn't have enough evidence that proved, and him saying this will affect me in deliberations because he did something. Jurors 11, 13, and 31 sort of countered this by saying, but we're the ones that determine guilt. The burden is on the state. And then I think Juror 31 went on about how he had been arbitrarily pulled over while delivering pizzas. And so they all understood Juror 6 to be saying, I think this guy is guilty. And then later on him saying, and yes, I believe law enforcement officers more. So I don't feel like there's any ambiguity in this current record that this person was guilty. Now, whether that could have been fixed by the magic question of can you be fair and impartial, I don't think it needed to be asked in this case, given his statements, but I don't think it could have fixed it here, simply because that people will come in with their own opinions. They don't always realize that is what we're talking about when we say, can you be fair and impartial? They might think their job is to defer to authority figures. That is what you should be doing. That doesn't make them unfair. That's just what you should be doing. So people don't always see those things as inconsistent. So the magic question doesn't fix things. And I think there's extensive discussion of that in several of the cases cited in the briefing, DeVore, Edmondson, all about the magic question fixing things. I also want to note that to the state's argument about Fuson being abused by defense attorneys and them just every time exhausting their peremptories just so they can preserve something for appeal. First off, that does not happen. That did not happen in this case. They were very clearly using their peremptories for valid, viable reasons. And I don't think it makes logical sense for defense attorneys who often face a difficult task in trying to find people who are going to be fair to their client. I don't think it makes sense for them to strike people they think would be good for their cause just so they can preserve something that maybe, not that likely, will result in reversal on appeal. So they're not going to tank the trial.
I'm sorry, real quick. If the foundation of Fuson is built on federal precedent that's been adjusted, wouldn't we have a separate obligation to correct that if it's not based on the state constitution?
No, I don't think so. So in Fuson, this court did note that the federal cases were shifting towards a per se approach. That was not a universal approach even at that time, but it certainly wasn't a universal approach in the many, many 39 years since that case was decided. Martinez-Salazar arose precisely because there was a split among federal authority. So Fuson was us choosing a more protective approach, and that's entirely consistent with what New Mexico has done in other circumstances. For instance, in Sanchez, in recognizing implied biases, we said there is a split in authority. We are going to opt to recognize implied bias because we can do that under state law, and it's important to us to fully protect this right. That was similar to Alvarez, they did that. So we've repeatedly been concerned about hidden bias, and we've repeatedly taken the tack of providing additional protection in that area, and that's all Fuson did. So no, I don't think we're bound by federal law to do what the feds do. In fact, I think the feds have made it clear we are free to do what we feel is necessary to uphold the rights of the citizens of this state. Thank you.
Thank you, Counsel. I want to thank Counsel for their excellent presentation today, both in writing and oral argument. At this point, I will turn it over to Justice Ed Chavez to answer questions. The court is going to recess with this case is deemed submitted. We will deliberate, and if we can reach a decision, we'll come back and announce it. Otherwise, the clerk will come out and release the parties. We will try and keep you updated as best we can with regard to the court's process in that regard. But for now, it is deemed submitted. We're in recess.
Attend the court, please. You all may be seated. Good afternoon, everyone. My name is Elizabeth Garcia. I serve as the Chief Clerk of the Supreme Court of New Mexico, and I just wanted to say it's an honor and privilege to be here today with so many wonderful, engaged students. I have the honor of introducing Justice Chavez, who's going to lead us answer session. Justice Edward Chavez was born in Santa Fe and graduated from Santa Fe High School in 1974 when he was 16 years old. He received an undergraduate degree in 1978 from Eastern New Mexico University and earned a Juris Doctorate law degree in 1981 from the University of New Mexico School of Law. I attribute my success to Eastern, acknowledged Justice Chavez. Eastern New Mexico University laid the foundation for my career and was the perfect size for me to succeed. I would have been lost at a larger institution. Eastern New Mexico University honored Justice Chavez in 2008 with the Outstanding Alumni Award, and the UNM School of Law honored Justice Chavez with their Distinguished Achievement Award. He was elected to be a fellow in the American College of Trial Lawyers and the International Academy of Trial Lawyers. The Supreme Court's robing room in Santa Fe, New Mexico, is dedicated to Justice Edward Chavez. The deep and longstanding respect that he has garnered from New Mexico citizens, students, and diverse sections of the New Mexico Bar is a testament to his leadership and commitment to the New Mexico judiciary and the legal profession in New Mexico. Welcome, Justice Chavez.
There's microphones to the side. Ladies and gentlemen, if you have a question, please make your way to a microphone, and Justice Chavez will take care of you.
Thank you, everyone. It's always a pleasure for me to come back to Portales, New Mexico. It was back in 1974 when traveling I-40, taking a ride at Melrose, ending up in Portales was a new experience for me, one that I did not realize would be life-changing. I actually started school as a 16-year-old, too young to begin in college, but had I gone to any other university, I believe in my heart that I would never have succeeded. It was a life-changing experience for me for the following reasons. I didn't appreciate school. I didn't think I needed an education. I wasn't going to make money going to school. So I couldn't understand why I had to continue. Well, my parents explained to me that they had borrowed money for a full year. And so after I told them after the first semester I wanted to quit, they said at least finish out the year. Well, to honor my parents, I did that. I grew up working on small cattle ranches in northern New Mexico and thought that's truly what I wanted to do, is raise cattle. But as luck would have it, the second semester, I met a Vietnam veteran in the library studying. He came up to me. It just so happened we both drove similar cars, 1969 Chevy Novas. Anyway, so his interest is, were you the guy that drive the Chevy Nova? And after we got to know each other, this Vietnam veteran told me his story, and his story of wanting to become a lawyer. And the reason he told me he wanted to be a lawyer was because he wanted the opportunity to speak for those people who could not speak for themselves, either because they were muzzled, not educated, didn't have the confidence, didn't know how to navigate the bureaucracies. And so I went home to my dorm room that night, stared up at a dark ceiling all night long thinking, what the heck is wrong with you? Your grandpa and grandma were kicked off of their land by the government. Had they had a lawyer, that would never have happened. See, they ran a little gas station along I-40, and the government kicked them off their land. So they had to move to a ranch where we didn't have running water, we didn't have electricity, and so it was a different living environment. That was the reason I wanted to go to law school. And if it weren't for this school, a professor by the name of Ross Sanchez, who taught business law, helped me navigate the process, how to apply for school, for law school, I would never have become a lawyer. So I owe a tremendous amount to Eastern New Mexico University. Have been back numerous times, but that's pretty much my history. And all I can tell you is if I could do it, any of you could do it.
So Justice Chavez, we did have a question asked by a student saying, I'm very interested in becoming a lawyer, but no one in my family has ever gone to law school. What is your advice to students?
That's a great question. If I go back 50 years, I can tell you what I did, but times have changed. I was the first one to get a college education in my family, much less a law degree. I didn't know what to do, but what I did is I did reach out to a professor who taught law, who let me know that I could not get a law degree at Eastern New Mexico University, that I would have to go to a law school to do that. They have admissions requirements. What I would do if I were you is I would get a well-rounded education. Back then, I don't know if they had an LSAT preparation book, but you want to prepare for any standardized exam. It's a must these days because the schools are now looking at what your scores are for the LSAT. And so you want a well-rounded education. You want to prepare for the LSAT. You want to engage in the community because a lot of what will make a difference in getting into law school is what your background suggests to you that you would be a good lawyer. I think New Mexico is starving not only for doctors in rural New Mexico, but also for lawyers in rural New Mexico. So think about your background, start planning, prepare for the LSAT, and be sure to connect with your community so that they know that you are somebody who cares very much about your community. And I will say about what you've heard today, it's a wonderful thing to experience. Justice is a community project. And people in our state directly participate in that project we call justice by participating as jurors. And when they walk into a courtroom, especially a criminal case, the person that is sitting there is somebody who, yes, is accused, but is innocent until proven guilty, as are the jurors. The jurors are believed to be impartial until proven otherwise. And whether or not the lawyers made the case here is up to the justices to decide. But justice being a community project tells me that you should be engaged in your community. Our democracy deserves what you put into it. And if you are apathetic, you deserve very little in our democracy. So participate in any organization, any agency, any branch of the government that you believe can make a material difference in your life or the life of your loved ones, and get active in that community. That will reflect very favorably on you as you apply to law school.
Justice Chavez, we have some students at the microphones that want to answer some questions, so I will let them take the lead and answer their questions.
Hi, my name is Jaden Lucero. I'm from Clovis High School, and I was wondering what the original number of peremptory strikes that a defendant has in a case with and without a cause.
Peremptory challenge is 5. And so if you exhaust all 5, then you're out of peremptory challenges. And those truly are designed to just address the situations where you could not establish that the juror would be fair and impartial.
Thank you.
Thank you. Very good question.
Hi, my name is Natalie Jennings. I am also from Clovis High School. And my question is kind of split into 2. But throughout our briefing that we're given before we come into the court, as well as what we're hearing during oral arguments, we hear a lot about what Juror 6's remarks are. And obviously through oral arguments, we learn that there is a bias that's trying to be established. So why is removing these biases and really identifying what the biases are so important to not just defense but prosecution as well? And then my second question is, how do we take action after the fact if these biases go under the radar?
Very, very good questions, but how you establish bias, because frankly, let's be clear here. We all go into any meeting, any hearing with an open mind, but also preconceived judgments. And what these partiality issues are is whether you have a preconceived judgment and you're going in and you say, you know, I believe all officers because they have taken an oath to abide by the Constitution, or I don't believe officers because I've seen too many false arrests, or whatever your preconceived judgment is. The question is, can you set that aside and sit and listen to the evidence fairly and impartially and reach a decision? As to what you do, I think the voir dire process, that's where the lawyers question the jurors at the beginning of the trial, is a very effective approach if the lawyers will listen with their ears and not their tongue.
Okay.
The biggest problem for lawyers is that they can't do that.
Yeah.
But we want to hear from the jurors. We don't want to hear from ourselves. We don't want to inject bias to the jurors. We want to make sure that they aren't biased. This is a very unique case. It truly is. In my mind, I won't give you what I think the answer should be, but one of them, I think you've heard sort of a theme building here.
For sure.
From the prosecution, that maybe when it went to trial, was there competing testimony?
For sure.
Because it wasn't the premise that this officer would be believed over competing testimony? And what do you do with that?
Okay, so I have kind of a follow-up question.
Okay.
So throughout our oral arguments, we also hear that rehabilitation never happened. So if rehabilitation could have happened within this case, how do you think that it could differentiate why we're here today?
That's a good question. How would rehabilitation take place? There's actually some language in one of the cases they were arguing about where the court ruled in favor of the person challenging the juror and then said they presume prejudice because they ran out of peremptory challenges before the jury was seated. That presumption was not rebutted. I am not entirely clear what that particular court meant by that, but what it might have meant is the state would have had an opportunity to go attempt to rehabilitate the witness by saying, understand that you have had positive experiences with police officers, but could you set aside your preconceived judgment about it and sit fairly and impartially? That's the target question that everybody quivers when they think about asking it. But I think if you think about it, the other approach you could take is, when somebody has announced that they believe police officers over other individuals, do you understand that this gentleman is presumed to be innocent until proven guilty beyond a reasonable doubt by the government? Yeah. And if they agree with that, then I think you continue to work with the juror to rehabilitate them, that they could sit and be fair and impartial and listen to the evidence.
So on a hypothetical level, this not happening in this case, that had an effect on why and how the jury selection process went within this case?
I'm sorry, repeat the question.
Sorry, that was kind of weird wording. But the fact that rehabilitation didn't exactly look correct in that sense of how you just explained it, did it have an effect on how this case and how the jury selection within this case played out?
The defense would tell you that yes, it did, because they used unnecessarily a preemptive strike. And they would have used it with a later juror, or might have used it with a later juror. The state, on the other hand, would say, well, you should have shown that there was another juror that you tried to excuse for cause and the judge refused to excuse that juror as well. Or you can look beyond that and you can say, was there competing testimony at the trial? If not, then was there harm?
Yes. Okay, thank you.
Sure.
Thank you. We have some students here. I want to make sure we get to them.
Hi, my name is Faith Fadari, and I'm also from Clovis High School. And I have two questions. My first one is that, according to the defense's opening remarks and a question asked by a Supreme Court justice, preemptive challenges, they aren't constitutional in the federal constitution or the New Mexico Constitution. So why is it relevant to this case? And then my second question is, what classifies as cause for a challenge of cause?
The reason they are part of the case is because the New Mexico Supreme Court has what we call superintending control over all the lower courts. They manage the courts, and they also have the right to dictate what the procedure is to be followed. And in what the rules have provided is they allow each side a certain number of strikes, whether you're in a civil case, criminal case, the Supreme Court has made it a rule. So it's really a rule based on the constitutional authority of the Supreme Court. And the second question was?
What classifies for cause in challenge for cause?
Basically, you have to establish that the juror cannot be fair and impartial in the case. There have been plenty of times when a juror has come out and admitted that they could not be fair and impartial for a variety of reasons, whatever those reasons are. And if you ask them if they can set aside their preconceived judgment, can they sit and be fair and impartial, they'll say no. Those are the clear ones. This is one of those cases where one would say that once he says, we're here for a reason, the officer probably had a reason to pull him over and has enough proof of guilt, then he's prejudged. That's a preconceived judgment. Somehow you have to get that erased.
Okay, kind of a follow-up question is...
By the way, I think the words of juror number 6 are very important. They should be verbatim, and there should be no doubt about what the juror said before you suggest that he cannot exercise his constitutional right to serve as a juror, because it is a constitutional right. In fact, we allow non-speaking jurors by constitution to serve on our juries.
A follow-up question is that the juror process, to my understanding, it is fairly random. Is there anything that's done to minimize bias based on, like, juror 6 maybe having family in the law enforcement and have more, they put them on a higher standard or pedestal. Is there anything done to minimize that bias in any of the jurors at all?
I'm not sure that the judge would have the power. If somebody feels strongly in favor of one party over the other, I'm not sure the judge can take care of that problem themselves. In fact, I think it's a lawyer's obligation to do that. Now, the judge could invite the opposing party to ask further questions of juror number 6, for example. That's a possibility.
Thank you.
Thank you.
Hi, I'm Samantha Lee, and my question was, how do strikes work? For example, the requirements, and what are the liabilities that come with it?
How peremptory challenges are done and the consequences that come with it?
Yes.
Okay. The procedure is, and it could be different in the courts throughout the state. I tried a lot of cases throughout New Mexico, and judges treat them differently. Some will sit 100 people at one time. Some will only sit 12 at a time. And so you ask each juror the questions that you want answers to. And at the end of the questioning, some judges will allow you to go right after the one juror, approach the bench, make your pitch for a cause. You can then wait, and at the end of all of the questioning by the judge and the lawyers, then they can meet, and the judge can ask, going one by one by one in numerical order, of what the parties say. One party could say, I exercised my peremptory on that one because they didn't think they had cause. Another one, a judge could ask, another procedure would be a judge to ask, I want all the 4 cause challenges first, one at a time, one from the state, one from the defense. There's a variety of ways that a trial judge could do it and have done it. And the consequences can be that you end up with jurors that you don't like for whatever reason, and that's the reason for the peremptory challenges. You just have this gut feeling.
Thank you.
Thank you. We have another question that was asked in advance. A lot of students are beginning their professional careers in college, and some are students in high school. Justice Chavez, what lessons have you learned outside of law school and being on the bench that you would like to impart to these young people?
Outside of law school while being on the bench? That being a judge is much more difficult than being a lawyer. As a lawyer, to me, it was easy because you argued the cause of your client, and you argue that vigorously. As a judge, you want to get it right, especially if you're on the highest court. You can look at it as the court of last resort, or you can look at it as the last court to be wrong, which makes it right. So it's very important for the judges to really analyze the case and take care of it. I also learned from law, being a lawyer, that the law is a key means for your participation in our democracy and to right a wrong, whether the wrong was caused administratively, politically, or economically. It's a powerful tool because you learn how to be an advocate. You learn how to write. You learn how to speak on behalf of people. You know what is persuasive, what is not persuasive. It's a skill that even if you don't want to be a lawyer, it's going to be a valuable tool. If you want to be a business person, you're going to understand regulations. You're going to know how to navigate the regulations, know how to interpret the regulations, know how to argue for a change in regulations. So the law provides a key means for doing a lot of things in society.
What would you tell a young person who wants to become a judge, but they're very nervous about that and they don't believe in themselves?
First of all, always be true to yourself. In your self-reflection, you want to be honest with your critique. You don't want to be hypercritical of yourself, but identify your weaknesses and your strengths. And when you identify your weaknesses, then figure out a plan on how you will improve those weaknesses. You can't just accept them as weaknesses and forget about it. You've got to work at it. And there are a lot of resources out there that can help you with whatever it is you think your weakness is. I had weaknesses. Eastern actually helped me through some of the weaknesses. I had rather thick accent, in speech classes here at Eastern New Mexico University helped me through that. Don't be afraid to be self-critical, and don't be afraid to reach out for help.
That's wonderful. I think we have another question up here.
Yeah, my name is Stephen Brust. I'm the professor of political science here, head of the legal studies minor and political science minor. So I'm very thankful that you chose to come here to the campus and present this case. It's a great opportunity for our students in the community. My question pertains to the judges, and I'm assuming that they have briefs written by the lawyers here, and they've kind of gone over them, thought about the case and everything. Do they come in with kind of a inclination towards one direction, kind of deciding, and then they maybe just want to offer questions that might rebut that? Or do they try to come in as much as an open mind, even though they have all these briefs, they've gone through them, et cetera?
First of all, they do get written briefs from the parties. So in this case, the Public Defender's Department wrote their brief. They have page limits. The state then gets to read that brief and file an answer brief, and then the public defender would get an opportunity for a reply brief. Not only do the justices get those briefs, but they also get the transcript of the court proceedings so that they can read for themselves or hear for themselves or have transcribed for themselves what the evidence was that is at issue. Now, whether or not they come in preconceived, that's an individual thing. My experience on the court, there were 5 of us. 5 of us reviewed the case on our own. Somebody is assigned authorship of that case. We don't know who that is until the clerk advises us. It's a random rotation. I think that the benefit of oral argument is substantial, because I sat on a number of cases where my colleagues or myself said, this is going to answer your question. I had come in prepared to go this way, but now I have been persuaded that would not be the correct way to go. So I think oral argument is really important. So there's that. In addition to that, what they're doing back there right now is they are going one by one, talking about how they see the issue, how they would approach the issue, and how they would make a decision. Then the next justice would then either rebut or just come right out and say how they would rule on the case. So then they have the benefit of each other's thinking on the subject. So it's a long process, but I don't care. Even if you go in thinking, here's where I'm at. I always thought the best questions were, if I don't understand, if I could not articulate a party's argument, it was my job at oral argument to help them flesh out their argument so that I could try to understand it. Because I think it's a bad idea to reject an argument you don't understand.
Great, thank you very much.
Sure.
Hello, my name is Quentin Ray. I had a question, and you kind of touched on it, but when the justices go back in the back room and they're talking about it, is it like, well, you jerk, I think this is the way it ought to be, or, how does that work? Because, I know in our court, they're elected, but, in the Supreme Court, you have different parties and different people appoint them, and, in the news media, they portray it as this side versus this side, but how does it work as a justices?
My very first day on the Supreme Court was oral argument day. I was considered to be the junior justice because I was the most recent justice appointed to the court. I'm going to tell you my story, and it's going to answer your question. I go in to the robing room. It's where you have 5 chairs around a table. That's where you meet before you go out into the courtroom to listen to the case. And I put my robe on because everybody else had their robe on. I then got up when the chief announced that it was time to go out. I went to open the door because I wanted to be a courteous junior justice, and I was scolded. Junior justice, I was told, The Chief Justice opens the door, and you go out first and go to the left. Okay, so I go out, I go to the left, and I sat down. Junior Justice, you wait until the Chief Justice tells you can sit down. So it was a learning experience. Then after the case, I had to open the curtains and be the last one out. I asked jokingly, well, why does a junior justice always have to go in first and come out last? Well, if somebody's upset with you and they've got a gun, it's better you get. I think that was all in jest, but anyway, we sat down because I was a junior justice. I got to go first on that case. I laid out the case as though I had it down pat. And then the second justice started to talk about why he disagreed with me. Well, he said something during the course of his presentation that wasn't clear to me, so I asked a question, and I was scolded. Junior justice, you wait until everybody has had their turn. Don't you ever interrupt somebody until they're finished. So that answers your question. One at a time, they get to finish, no back and forth. I think the back and forth would be healthier, though.
Thank you, sir.
Thank you. What parts of the job of being a Supreme Court justice on the New Mexico Supreme Court have inspired you, particularly when the work of being a justice is difficult?
I think if I learned anything being on the court, it's that we are a country that inherited an obedience to the rule of law. And the only difference between the rule of law and rule by whim is procedure. So I think we need to cautiously, but we need to guard the procedural rules that we have and that are set forth in the Constitution. That to me has been important. But also how courts can help with societal issues became also important to me. We have a number of drug courts that we're proud of, veterans courts, things of that nature that are not necessarily related to litigation, but very helpful in terms of reducing what we would say repeat offense or repeat addiction. And those sorts of programs to me have proven invaluable in the state of New Mexico. If only we could have more of them.
Well, I'm getting word that the court is going to return from deliberations, but I wanted this audience to thank Justice Chavez for leading us in a very thoughtful question and answer session for today's Rule of Law program. And thank you for your service to New Mexico.
Thank you.
Attend the court, please. The Honorable Supreme Court of the State of New Mexico.
Chief, I apologize.
Good afternoon. You may be seated. Thank you. Good afternoon, and thank you for your patience. We're back on the record of S-1-SC-40404. State versus Mendez. I want to again thank counsel for their presentation. The court has recessed, deliberated over the matter, and is prepared to issue an opinion today. A written opinion will follow. The court concludes that defendant properly preserved the arguments for appellate review. Juror 6 statements will be reviewed in their totality. The court concludes that the district court abuses its discretion in denying defendant's motion to strike. Juror 6, based on bias, based on the statements of Juror 6. Defendant was prejudiced by the district court's abuse of discretion because of the use of the peremptory strikes, including one on Juror 6. The court believes, based on a review of the record, should have been struck for cause. Defendant is entitled to have the conviction reversed and the case is remanded for a new trial. With that, a written opinion will follow in due course. I want to thank the court, my colleagues. I want to thank all of you for your kind attention and for participating in this program. The court is in recess.
Attend the court, please. Thank you all very much for a very engaging 2026 Supreme Court of New Mexico Rule of Law program.